You are taking a blind shot from the tiger. What Supreme Court is this?
Supreme Court has guided.
Very good evening to all of you. On the way coming here, when DPN Saran and I were talking, he just mentioned possibly this is the first of the discussions that anywhere that he's aware of also that is happening on this ruling. Thank you. Thank you for all three of you to actually be a part of this discussion. In fact, I've mentioned this earlier. I'll mention it again. It's a privilege to see all three gentlemen sitting to my right in a single frame. I mean, I think all of us sitting here will agree to that. Thank you, sir. Thank you so much for making this happen. So this is like the brochure itself tells. It's a discussion on the ruling of the Supreme Court in the case of Gameskraft. We would have possibly read, many of us would have possibly read what is there in the social media, what is coming as snippets, etc. But very few of us would have gone through the entire 400 pages. So we have three gentlemen sitting here who have definitely read through the entire 400 pages, and we are going to have a good discussion with them. Just to give it a start, sir, I would possibly not take only the card game, even the casinos, even the race club, basically the concept of actionable claims in this entire discussion. Sir, if we look at how the law has kind of evolved from 2017 till now, possibly it may be a very not a rude statement, but yeah. Sir, I think somewhere government was also confused on the actionable claims piece, whether it is services or goods. While there have been some precedents in the past to say it is goods, some of the changes, some of the amendments which have come into the law between 2017 till 2022, sir, have a flavor of both goods and services, especially when we talk about these actionable claims. Having said that, we have a ruling by the Supreme Court which kind of overlooks or maybe sets it aside on the need for a differentiating game of skill versus game of chance. So let's hear it from all three of them for the next 1.5 hours. The format is going to be where we are going to hear Mr. Shivdas make a presentation on the entire ruling for about 45-50 minutes. Then it's a panel discussion with the three of you, sir. Thank you, sir. Over to you.
Thanks for the invitation to be here for this presentation. The decision in Gameskraft was a much awaited decision, both by the industry and by the department. The way the arguments went on for maybe about 20-25 days or so from both sides. All possible arguments on why it should be taxed and why it should not be taxed both were advanced. And I'm sure the people who argued the matter and came back also came back with a sense of feeling that they have been heard completely on all their points. Decision has come. I mean, to me personally, I have not done this matter. I have not even looked at this issue at all at any point of time. But when I read through the decision as somebody who's looking at the controversy for the first time and having regard to how tax law has evolved over the past 30-40 years, pre-2017 and post-2017. To me, the judgment is definitely a disappointment. Why I say disappointment is this. While with due respects to the courts, we can't say that the Supreme Court is wrong, because at the end of the day, it is the Supreme Court. So we can't say it's wrong on any aspect. But I think the way the decision has gone, and by the fact that the decision is of 417 pages, and the actual decision starts somewhere in 263 pages. 62 pages. So roughly you have about 200 pages of judgment. As students of law, we have always been taught that the longer you write a judgment, you get stuck into something where you find it difficult to come out. Due respects to the judges who have written this, we could find the judgment proceeding on all points at every point of the decision. Though there is a manner in which the decision has been worded, we have a preface, and one of the very few decisions we have a preface to a decision. So we have a preface, and then you have the arguments, and then the decision, etc. Well, that is there. But somewhere I thought they seem to have lost sight of.
Purushottam, put everybody on mute, no?
Sure. Actual controversy that was before them. And the judgment is more an analysis or a discussion on what is the impact of this online gaming on the society, rather than a decision on taxing online gaming. That's
Moral judgment rather than a taxation judgment.
taxation. Now, while that is one aspect of it, the other is, while nobody disputes the ultimate decision of the Supreme Court to say that online gaming is taxable. You want to tax it as goods, you want to tax it as a service, that is fine. That's not a, that's ultimately the decision of the Supreme Court, and all of us are bound by it. But a number of observations on a number of other issues is what, according to me, concerns us, because those are observations that can be picked up in a stray manner and can be used by the department against the assessees. That's where the matter of concern is. It's really not of the decision on the taxing of online gaming, but the way the decision has gone about saying that it is taxable not from today, but from yesterday on the total value. Somewhere we seem to have lost sight of the fact that at the end of the day, as a businessman, I'm supposed to pay tax on what I receive, on not what I am purported to have received. Tax law never proceeds in that manner at any point of time. So that's where I think the problem this decision can create as we look forward. We know the decision will have some impact as we go forward. So what we will do is we will quickly run through the decision. We put it as, I've tried to capture it in small bullets. What were the facts and what were the contentions? And before we get into the decision, what was the position of law? Like Badri was pointing out, what was the stand of the department pre-2012, post-2012, pre-2017, post-2017, and then how the decision is being made. So we will have a quick look at it. I'll try to cover it maybe in about 35-40 minutes. I've tried my best to put it in that 35 minutes, but reading this 417 pages took about a week. So that is what was difficult. Yes, please.
Not only reading this, but you have to read it along with the intertwined judgment.
Absolutely. And more surprising, in fact, as DPM sir is saying, the decision in Jungli and this decision seems to have been passed on the same day. The decision in Jungli came, I think, maybe a day before, and this has come a day after. And on the taxability of online gaming, this decision relies entirely on Jungli decision, whereas Jungli was not on the taxability of online gaming. So having decided that this has to be taxed, so you frame your decision first, and thereafter you go about trying to fix various issues relating to that. That's how this decision seems to have gone. I mean, the Supreme Court always says that their decisions can be opinions can be expressed. These are all opinions which we are expressing on the Supreme Court decision, not that these opinions will matter much to court. So what we'll quickly look at is this. So in Gameskraft, it was essentially running a platform that allowed users to play games against other users. And the games were rummy, poker, and other card games. That's how essentially it started off. So it was running a platform. One user can play against another user. And these were the games that were generally played. You can have more games being added, etc. But this is how they started off. Now the department contended that Gameskraft was involved in betting and gambling. This betting and gambling is in the nature of supply of actionable claims. Therefore, it's not merely a question of giving a platform. They cannot be said that they should be liable to pay tax only on the platform fees which they were paying. They should pay something much more than that. That's how the whole thing started as far as Gameskraft is concerned. Now, notice was issued. It was challenged before the High Court.
Yeah.
And the High Court here, the matter also was heard in quite detail. The High Court ruled in favor of the SSE, saying that these are in the nature of games of skill or games of chance, and therefore, in terms of the Transfer of Properties Act, it has to be excluded as it is wagering contracts are to be excluded, and therefore, ultimately, the High Court ruled in favor of the SSE. The challenge was to the Supreme Court, and the Supreme Court's order is before us. Now, typically, if you see how it operates, is this. There will be a player A who will deposit 100 in a platform. Platform will, let's assume, is of Gameskraft. There will be a player B who will also deposit 100 rupees. So player A will play against player B. Now, Gameskraft, which runs the platform, has 20 rupees as its fee in that 100 rupees. So it collects 20 rupees from both player A and player B. And on that 40 rupees, which is its fees or its consideration, the amount which it gets from both the parties, it discharges tax. Now this 200 rupees minus the platform fees, it goes to a prize pool. And then ultimately when player A and player B, one of them wins, they receive the entire amount. So this is how typically, on a very simple scale, this is how it operates. There are much more variations to all this, but I think this example is good enough for us to understand how the whole thing operates. Now, the High Court said, the Karnataka High Court, that said this game of rummy is a game of skill, whether it is played online or whether it is played physically, whether it is played with stakes or whether it is played without stakes. Therefore, the High Court said that these games constitute actionable claims not amounting to betting and gambling and is therefore not subjected to tax under GST in terms of Schedule 3. The High Court also examined, saying that there is no difference between offline and physical rummy and online, and held that substantially both are games of skill and not of chance. The High Court quashed the show cause notice. Similar matters in different high courts also were there of different variations of activities. Some of the high courts ruled in favor of the SC. Some of the high courts rejected it on ground of you have come too early to the court and all that. Therefore, all of them have come to the Supreme Court. Either the revenue was on appeal or the assessees were on appeal.
They're all transferred.
All of them were transferred. So broadly, this is how the whole thing. Online gaming platforms or fantasy sports operators, online poker platforms, industry associations, all of them were part of the total activities or the controversies parties before the Supreme Court. Now, what is the SSC's content in all this? And this is the common contention by all the SSCs. If you look at the decision, all the counsels who argued broadly had these arguments in different formats. All of them said that the common factor in betting, gambling, wagering, and gaming is chance, and is distinct from activities where skill constitutes predominant element. Winning or losing is dependent on the skill of the player and cannot be altered by stakes. Because I put 100 rupees or I put 1000 rupees doesn't mean I will succeed unless I have a skill to play. Then they said void agreements fall outside the ambit of actionable claim. And why the SSC said was the definition of actionable claim in GST refers to the Transfer of Properties Act. And surprisingly, that even after all these amendments, that reference to the Transfer of Properties Act has not been removed from the GST laws. Therefore, if by virtue of the decision of the Supreme Court today, it is not a wagering contract. I don't know what purpose that reference to the Transfer of Properties Act would survive in the Act today after this decision. So the void agreements are outside the ambit of actionable claim. Online gaming companies merely rendered platform services. So historically, any tax that is levied on betting and gambling is understood as a tax on activity and not on goods. Because what is being taxed is the activity of playing with or without stakes. Therefore, it is the tax on the activity and not on anything beyond that.
Including entry number 62 of the list 2.
Including entry number list 2 of list 62 of list 2.
Okay.
Then they said the levy is on a completely artificial valuation, because what happened was the introduction of rules 31A, 31B, 31C, etc. said you should pay tax on the total face value. And very surprisingly, that rule also said that suppose somebody gave me a good example when after this decision, somebody was talking to me on this. Suppose I go to a casino, I buy chips worth, let's assume 1 lakh. I choose to pay only 20,000 rupees. I use only 20,000 rupees chips. I don't play the remaining 80,000. Going to be the position. Merely because I have purchased chips worth 1 lakh. If you look at the decision, it says there is a supply of an actionable claim worth 1 crore or 1 lakh because you have purchased chips worth 1 lakh. Irrespective of whether I will play or I will not play. Or suppose I purchase chips of 1 lakh. I indeed use it. But at some point of time, I say that I would like to withdraw about, say, 30,000 rupees from that 1 lakh. All these are possible. It's not as if it's not possible. The valuation mechanism says that irrespective of what you withdraw, you should pay tax on the total 1 lakh. Therefore, the SSCs argued, you look at it the way the tax is being levied, a completely artificial valuation, and is even higher than the revenue of the entire online gaming sector. In fact, if you look at the decision, Mr. Salve has given an example. The 10 rupees is the consideration which the platform receives, and you're asking him to pay tax on some 28-30 rupees, which normally doesn't go with any industry, be it service, be it goods. Then it said auctionable claims and money are specifically excluded from the definition of goods under Section 2(7) of the Sale of Goods Act. But the definition of goods under the GST specifically seems to include actionable claims from 2017 onwards.
252 clearly includes goods definition to includes actionable claims, and that primarily was drafted keeping in mind the Sunrise Association.
Actionable claims belong to a different category of juristic property rights. Then 31A3 is violative of Section 15 as it imposes GST not on the actual consideration, but also on the gross stakes. Because when 15 uses the expression consideration, it means amount which I receive. You may call it gross, you may call it net, but it's the amount which I receive. And gross is not an expression being used in GST for the first time. It has been used in service tax law even earlier. And that has been interpreted by the Supreme Court to say that you merely because the expression gross is used doesn't mean you can put everything when actually it doesn't represent your net consideration.
By unbuilders.
By unbuilders. So therefore, this is what are briefly the contentions of the SSCs. There's nothing which departed from the earlier understanding of the trade prior to the enactment of this laws. All of them were said historically, this is how you have been taxing us, you have been treating us. So how do you make a difference in terms of your approach? Now, this is what is the contention on behalf of the department. They said any activity involving stakes constitute gambling, regardless of whether it is skill-based or chance-based. In other words, the moment you put in money, it becomes gambling. So whether it is skill, whether it is chance, it is effectively not relevant. And if you look at the decision of the Supreme Court, they have practically diluted the difference between chance of skill, the game of skill and game of chance. They said that is irrelevant because you are playing with stakes. Therefore, it becomes gambling. Then the department said, operator of any game, including skill-based games, supplies what is actionable claim in the form of a chance to win when stakes are involved in such game. So according to them, according to the department, the moment I play with money, I put in my money, then the platform gives me what is called supply of an actionable claim. Since actionable claim is goods, therefore, there's a supply of goods by the platform to the person who is wanting to play. Therefore, the platform has supplied goods to the player. In fact, to the credit of both the department, I think I should say they flipped around the entire argument to move away from services. Because if you say it is services, you get stuck on the net consideration of a platform. So I think it's a very clever argument to say that it is actionable claim. Your game of skill or game of chance is irrelevant. And therefore, it is actionable claim is considered to be goods in terms of definition of goods under the GST law. Therefore, there's a supply of goods. The moment it becomes supply of goods, then the entire amount which you stake becomes a consideration which you pay for supply of goods. Therefore, that entire 100 rupees becomes taxable. That's how they flipped the entire argument, and the Supreme Court seems to have approved it. Now, what consequences it has, we will see slightly later. Then, as money is considered a movable property, winning pool constitutes movable property. The difficulty was movable property of whom? There are 2 players, 3 players. Does it become the movable property of all the 3? See, when you talk about supply of an actionable claim, you talk about a supply of an actionable claim the moment I make my stakes, not when I win. Supreme Court says when you win, what you win, how much you get is all completely irrelevant. The moment you participate, there is a supply of goods by the platform, and therefore the winning pool becomes the movable property.
And the creation of the actionable claim also triggers the tax.
So the everything gets diluted, but once you approach the matter in this manner, that we will treat it as a supply of an actionable claim, and the amount which you stake in becomes the total amount, and that is the value for the actionable claim supplied to you, and you are liable to pay tax. Everything else becomes slightly irrelevant according to the Supreme Court. Then every player has the vested right to claim the winning amount, and the pool is under the control of the operator. Why this argument was raised was the assessors argued that at the end of the day, or even the operator argued, at the end of the day, when I keep 100 plus 100, 200 rupees with me, keeping my 20 rupees off, on the 180 rupees, I am essentially acting it as a trust, as a trustee, as somebody who has been given the entrustment of that 180 rupees. That 180 rupees doesn't belong to me.
It's an escrow account.
It's an escrow account. Therefore, they say that how do you ask me to pay tax on that 180? The government seems to have said no. The pool is under the control of the operator. Therefore, they are right in asking the tax to be paid on the entire 180. Now, I'll each one of them when I have these arguments, I'll park and give my thoughts. Now, I was only thinking, suppose I put in a stake of 100 rupees. Then 20 rupees goes off, it becomes 80 rupees. 80 rupees, I win it as 150 rupees. I want to play this 150 once again. 20 rupees again goes off as platform fee. Let's assume 130 rupees. Now this 130 rupees, I again stake. 20 rupees, 130 rupees becomes, let's assume 200 rupees. 200 rupees, 20 rupees platform fee. I stake 180 once again. Going by the decision, the first actionable claim stops the moment the 100 becomes 130. The next actionable claim starts once I stake 130 and it becomes 180. That actionable claim stops at 180. The third actionable claim starts at 180 and it becomes 250. In other words, 3 actionable claims are being supplied to me by the operator. Therefore, I will be liable to pay on 80, or rather on the platform should, the operator should pay on the first 100, on the second 130, and on the third 180. Going by this.
Absolutely.
So if each time it's a 28 rupees on, 28% on, 100, 130, and your 180. Whereas the poor platform's receipt is only the 20 rupees at every level. Can there be a taxing law that can proceed in that manner? That is the serious concern in the decision. It's not a question of whether you want to tax, you don't want to tax, you want to tax online gaming. That's one aspect of it. But is that the way you can proceed to tax? Then the contract between the player and the wagering company is not a wagering contract and is valid and enforceable. Player can initiate lawful proceedings against the gaming company to recover the amount won. That is because wagering contract are excluded in terms of the Transfer of Properties Act from an actionable claim. Therefore, wagering this is essentially a wagering contract, because I stake and then I don't know what I will get. It's an uncertain event. I will not know what will be the outcome. Therefore, it's essentially a wagering contract. Transfer of Properties Act or the contract law says you cannot tax it, enforce it as a contract, because you don't know what is going to happen. It's not a valid contract entered into between two parties.
Section 30 of the contract.
30 of the contract. So the department says that's not relevant. It's not a wagering contract at all. And therefore, we do not get into it. They can proceed to against the platform fee, against the platform to recover the amount won. Concept of supply under GST is broad and all inclusive and cannot be restricted to traditionally recognized concept of transfer and sale. Now, there is an observation of the Supreme Court on this, and this is exactly that they have mirrored in the decision also. And this concept of supply under GST is broad, all inclusive, and cannot be restricted. Now, where these observations can lead to, we don't know. Where these observations can lead to, we don't know.
So far, our understanding has been supply is always understood in the context of goods and services.
Absolutely.
Which also found defined constitutionally. And when we brought in 101st Amendment, the services also got defined specifically in the Constitution. Now, if you look at services, we consciously excluded money and securities from the services concept. But by definition, immovable property was not a part of the goods. So that protection was there. But this species of actionable claims was always included in supply, and that is how in Schedule 3, the supply and exclusion of actionable claims, the carve-outs were only subject to tax. But if supply encompasses something other than goods and services, this is a new animal which we need to be very.
And we don't know where this animal will go.
Sir, I may ask you a question, you can address it. Concept of consideration analyzed in the decision. What constitutes consideration?
Yes, sir.
Has it come for any critical evaluation.
Yes, sir. There is an analysis of it, consideration, because I'll come to that, sir. I have a slide on that. I'll come to that. How consideration has been examined also has been seen by the Supreme Court.
I think this point, I think all of us need to very carefully look at it, what Shivdas sir has mentioned about. See, in a traditional sense, we all understood supply encompasses either goods or services or both. Now, we are looking at an actionable claim, and actionable claim as a whole, which is covered in Transfer of Property Act. We were only concerned about the carve-outs. Now, the carve-outs are post 2023, we are very clear. But we are also discussing in this part of the discussion the situation of actionable claims as it prevalent from 2017 to 2020.
Absolutely. Absolutely. That's the problem is post 23, you ask me to pay tax, either I survive or I don't survive. Simple as that. But if today in 23, you say this is what the law was from 17, and when the understanding of the administrators itself was not that, then are we looking at a situation where there is an overreach of interpretation? Quite possible. I don't know. I mean, we leave it to the courts again. Then they say taxable event is the supply of actionable claim by gaming companies and not betting and gambling. Entire stake amount is the consideration and forms transaction value in terms of section 15(1), and 31A is only a reiteration of section 15(1) of the GST Act 2017. Now, to park here, we have not still gone into the findings. The section 15 of the GST Act essentially is a self-contained provision. It marries what was there as a transaction value under the excise and the transaction value under section 14 of the customs. Essentially, it is that.
And also the open market value, which was followed by the VAT.
It's a self-contained code. You give everything. Now, 31A, when it says you should ask them to pay tax on the total face value, irrespective of the withdrawals of the amount, you should not be concerned with the withdrawals. It was pointed out that this therefore will be against the reading of section 15 itself, because section 15 says what is the actual amount, the transaction value of his goods or service. Even if you treat it as goods, you supply certain goods for 100 and then you receive 50 rupees back. That doesn't mean that the value becomes 100. The whole concept of credit notes, etc., is only to reiterate that if you say 100 today, you invoice an invoice of 100. If 50 rupees tomorrow is considered as a credit note, then your value for the purpose of GST becomes 50, and therefore you should pay tax only on 50. You may have a mechanisms to do it. You will have a credit note, then you will do an reiteration of it. You modify your GSTR and 1, all that you do. But ultimately, the tax is payable only on 50.
What is actually transacted?
What I earn, what I get.
Intrinsic value, basically.
What I get. In fact, intrinsic value could be even what I get in my hand.
Transaction.
For whatever I do goods, I do services, what I get in hand. The moment you say that no, what I get in hand is not relevant, what I initially offered, what was given to me is going to be taxed, then that basically goes beyond section 15, number 1. Now, I was reading closely how the Supreme Court gets over 15.4 and 15.5, section 15.4 and section 15.5. 15.4 says that if value is not determinable, therefore you can go to the valuation rules. And that's how the scheme is. And 15.5, they can still frame rules. That's how the tobacco products, MRP based, etc. was 15.4 and 15.5. What it therefore means is that if you have a transaction value, don't go to 15 valuation rules. And that's traditionally the understanding of everybody, the department, the trade, etc. for the past 30, 40 years. Somewhere the Supreme Court says, when 15.4 says that it is not determinable, it doesn't mean that it is impossible to determine. It may be possible to determine, but in the particular case of an industry, particular case of ambiguity, therefore, they can still frame laws which can go beyond section 15.1. Therefore, 15.4 enables the government to frame a valuation mechanism which can even go beyond section 15.1. Now, these are all dangerous observations being made. These are dangerous observations being made. Now, therefore, That's one problem we may have in this decision. Therefore, when you look at the issues, what was before the Supreme Court was this: whether online gaming activities involving stakes on uncertain outcomes constitute betting and gambling for the purpose of GST. Whether sections 231, 252, 7, 9, and 15, along with the relevant rules, are constitutionally valid to the extent that they levy GST on actionable claims arising from betting and gambling. Whether actionable claims are covered within the definition of goods under GST and constitute taxable supplies. Whether 31A is intra-virus the provisions of the GST Act. Whether the amendments introduced in 23 are clarificatory and retrospective on operation, and applicability of the analysis to online gaming, fantasy sports, and casino. Practically, the one brush they have done the whole in the treatment of all the industries, but these are all the various issues that were placed. Now, before we go to the findings, I think it is necessary for us to have a look at what was the understanding of the administrator even before GST law had come, because that will give us some understanding of how all of us understood this position.
That is from a taxing perspective.
From a taxing perspective. Right. Next one. Slightly. Okay. Now, if you look at the position pre-2012, now we had the definition of business auxiliary service and an explanation to the said phrase. And that service in relation to promoting or marketing of a service included any service provided in relation to promoting or marketing of games of chance, organized, conducted, or promoted by the client in whatever form or by whatever name called, whether or not conducted online, including lottery, lotto, and bingo. The reason why I am pointing this out is in pre-2012, the understanding of the administrator was we are going to treat it as a service. You may want to exclude it, you may want to tax it, but we want to treat it as a service. And that explanation was omitted from 1/7/2010. And they introduced a subclause to say that services provided for promotion, marketing, organizing, or in any other manner in organizing games of chance, including so and so, whether or not conducted through internet or other electronic networks. So all this practically, whatever we are talking about today, in some sort of an original form, was conceived by the administrator to be as part of a service and as was either taxed or was not taxed. That's how the position was pre-2012. Post-2012, now we got into the negative list and the general understanding of service, where they said defined for the first time an actionable claim and referred it to Section 3 of the Transfer of Properties Act. And the definition of service did not include an activity which constitutes a transaction in money or actionable claim. Therefore, under the service tax regime, actionable claim was not taxable. Now, 2015, they added an explanation to say that the meaning of transaction in money or actionable claim, in terms of which transaction in money or actionable claim does not include any activity relating to use of money or its conversion by cash or by any other method, as well as activity carried out for consideration in relation to money or actionable claim, including activity carried out by a lottery distributor. So in terms of the above explanation, any transaction in an actionable claim would not include an activity carried out for distribution of lottery by the distributor. Such activity would not amount to activity of betting, gambling, and lottery. This is how the position was till 2017. So till 2017, all of us understood, both the administrator and the trade understood that it is a service. If it is a service, I am bound by the Finance Act. And if in terms of the Finance Act, I receive a consideration, I am supposed to pay tax on the consideration. Simple. So the platform fee of 20 rupees, 20, whatever be the platform fee was liable to be taxed. And the industry, according to what we learned, industry was operating based on that.
It had also something to do with the fields of legislation by which pre-GST period had the list approach, where the center could have come into and taxed it only when it is clearly not included for the purpose of the fields of legislation covered by the state. Now, if you look at an actionable claim, it was not covered under the Sale of Goods Act as goods. Am I right, sir?
Correct, correct.
So in a way, it was not covered under sale for the purpose of levy tax by the states. But nonetheless, since it had been held as characterized as goods, the central government were to collect it unless it is at the excise level, the manufacturing level, where the field would have been there. In a distribution or in a sale transaction, while sale of goods did not cover it, probably I think the service entry by this what union has levied tax could have levied tax only by providing this carve out, not otherwise as a general actionable claim, which would have fallen into the species of goods.
Absolutely. Now, this was the position in service tax regime. Now comes the post GST regime, all before the amendments took place. Go to the next one. We started off with this, that the actionable claim shall have the same meaning as assigned to it in the Transfer of Properties Act. And the Transfer of Properties Act specifically gave a definition to an actionable claim. More important, on the right-hand side, there's a small highlight we have made. What is the chief ingredients of this definition? The claim to a beneficial interest in a movable property. Such movable property in respect of which the beneficial interest exists must not be in the actual or constructive possession of the claimant, and the claim must be one which is recognized by a civil court as affording grounds of relief. This is where, when wagering contract is excluded, in a wagering contract, you cannot raise a dispute for relief to the civil court. Therefore, this definition said you cannot subject a betting or gambling as a wagering contract, and therefore it cannot be considered as an actionable claim. That's how the whole thing proceeded. Now, if you look at definition of consideration, 231, consideration includes any payment made or to be made for the inducement or for the supply of goods or service, whether by the recipient or by any other person. So for the supply, whatever be the value you get, that is considered to be the consideration. What it therefore means is not the money you receive at the outset, but the money which you retain as a person supplying the goods. That is why if you look at the definition of consideration or section 15, any deposit that is made for the supply of goods, to deposit a supply of goods, that is not to be considered as unless it is appropriated towards the sale value of the goods. So 100 rupees that is given, unless it is appropriated to an actionable claim, which will happen only when I play and then I win. The moment I participate, to say that I get an actionable claim, and therefore you will, irrespective of whether you win or not, that a supply of goods, your 100 rupees becomes taxable. If you don't even get 100 rupees, flies on the very face of it when you look at the consideration definition.
And also an amplification.
And amplification.
You see, 1/7/2017 to somewhere up to January 2018, when any advance was received, it was made subject to tax and an amendment was carried out, and only the advance received in respect of goods, like what Shivdas sir has mentioned, was removed for the purpose of tax liability. In respect of services, following the service tax period, the point of taxation is to be either the performance of service, receipt of consideration, or the issue of invoice, whichever is earlier. In respect of advances, in respect of goods, the 2018 amendment brought back the position which was prevalent in the VAT law. In VAT law, when a tax was levied on sale of goods, it was actually on the sale consideration reflected in an invoice issue, which becomes a taxable event. By bringing an advance before issue of an invoice, that principle of the VAT law was not built into the GST. That was course corrected in 2018 by that amendment. All that I just want to say that.
Right. Now, definition of goods in GST law surprisingly included actionable claim because it wanted to go with its own definition of goods. Therefore, actionable claim was included in definition of goods in GST. Scope of supply. Supply includes all forms of supply of goods such as sale, transfer, barter, exchange, license, etc. And it also says, notwithstanding anything, activities or transactions specified in Schedule 3 shall be treated neither a supply of goods nor a supply of service. And Schedule 3 said activities or transactions which shall be treated neither as supply of goods nor a supply of services. Actionable claims were specifically put under Schedule 3 under Section 6, other than lottery, betting and gambling. And lottery, betting and gambling as was traditionally understood by the trade, traditionally understood by the department, etc. And that's the whole purpose how this amendment took place. Schedule 3 also was, in fact, Schedule 3, DPN sir will bear me out. Schedule 3 kept on getting amended over a period of time, depending upon the circumstances that the trade faced. The government looked at it, and then they, over a period of time, added transactions which were neither supply of goods nor supply of services, and therefore that's how there's a lot of thought that had gone into the framing of Schedule 3.
And it basically flew from the international best practices, where we used to have a concept called an out-of-scope supply. A supply, by its commercial sense, may still be understood as a transaction or activity, but for the purpose of the GST or the VAT law, they will not be construed as falling within the ambit of taxing legislation. So it's an out-of-scope supply transactions. We had listed it as a Schedule 3 and primarily borrowed all that negative listing which was there in the service tax regime. And we also, when we looked into the Schedule 3, we also looked at some of those things which were covered by negative list. Some of them were provided by exemption in service tax, and then brought it in a manner, in a very precise manner, like what Shivdas has talked about. For example, if you look at the reinsurance and the co-insurance commission as such, this was one which we have added as latest as 2023-24. So it has evolved, and it is continued to be an important method by which, if the intention of the legislature is to not to tax the supply, but to retain the input as credit on that transaction on the value chain, put it under Schedule 3, it becomes absolutely, fulfill that transaction in terms of retaining the input tax credit chain, but not tax the output supply, because exempted means the credit chain breaks.
Absolutely.
That's the purpose.
Yeah. Now, this is Section 15 of the GST Act. Section 15.1 is a transaction value. Then 15.4, where the value of the supply of goods cannot be determined under subsection 1, the same shall be determined in such manner as may be prescribed. What this means is that if parties to a contract, parties to a transaction are not able to determine the value under section 15.1, it gives them a scope to say, yes, now you don't have a method by which you can determine. We will give you methods by which you can determine it. That's how we get into open market value, cost, and all the different options are given. So the 15.4 proceeds on the basis that parties to the transaction are not in a position to determine, and therefore you go to the rules. If it is possible to determine under section 15.1 for the purpose of your supply of goods, it stops there. It doesn't enable either the parties or even the department to go beyond 15.1 and say that under 15.4, unless you doubt the correctness of the value under 15.1. Then you go to 15.4 and try to determine the value in terms of whatever methods are permissible. Now 15.5, notwithstanding anything contained in subsection 1 or 4, the value of such supplies as may be notified by the government on the recommendations of the council shall be determined in such manner as may be prescribed. Now it's quite possible. Now the whole purpose of 15.5 was, if it is necessary in a certain situations, the value cannot be determined under 15.1 or on 15.4. GST Council can decide, the states, the center, all of them can sit together and say that this is how we want to determine for these supplies, therefore we can do it.
The case
That
in
is possible.
point is the corporate guarantee.
Corporate guarantees, all that can be done. Or for example, if you take even the
tariff values,
pan masala, tobacco and all that, MRP was never a part of the taxing in GST law at all. It was always on transaction value. But for pan masala tobacco products, they brought in a notification saying you will pay tax on the MRP. Now that was challenged because it was notified, but there was no prescription under 15.5 for the purpose of that notification. The High Court struck it down. Therefore, those are all situations you can do, but you should be in a position to discuss, identify that for these transactions, we are not able to do it in terms of 15.1 or 15.4. Therefore, we want to do it. That doesn't mean the way the court has observed, they said 15.4 doesn't mean that it is impossible to determine. It may be possible to determine for the parties. But even if the parties determine, we can go beyond it and then do it, which I think goes beyond the fundamentals of even transactions. One. Now, if you're going to say under 15.5, the government has done it, maybe because of the GST Council meeting, etc. The moment you adopt 15.5 and frame laws, it goes without saying that it can never be retrospective. A notification under 15.5 making out the entire scheme of things of taxing can never be retrospective. Your 31C essentially seems to have been flown through 15.5. It can never be retrospective, but somewhere everything seems to have been decided to say that 15.4, the government can go beyond situations even where it is possible to determine. And 15.5, we have done it. And 15.5, since I have done, it was always inbuilt in the transaction value valuation provisions that this is how it should be taxed. Therefore, 15.5 and the rule 31C are clarificatory in nature. Therefore, it will apply for the past. I mean, you are given a complete go by to settled positions of law, which is what is concerning. This can throw open a complete Pandora's box for any number of situations.
And one of the arguments the petitioners made before the Supreme Court was that the machinery provision through which this value was applied is in terms of Rule 31A3. Now, 31A3 was not notified under 15.5, was also one of the argument taken.
Absolutely.
What Shivdas sir said is about it, 31B and 31C were specifically notified by virtue of this 15.5 read with rule section 164. 164 gives the power to the government to enact any rule with retrospectivity. Right, that is always there. But when 31B and 31C were actually brought into the statute book as rules, no retrospective was given.
Exactly.
This levy has been sustained by virtue of Rule 31A3, which is not notified under subsection 15.5, is an argument.
One. Two, the whole purpose of 164 is, once the purpose of 164, as I always see, is that if there is a procedure that is notified in order to, one, provide a relief to the trade, and it want to proceed with the scheme of the act. Like, for example, the Tran 1 notifications and all in GST, where they kept on modifying depending upon, all those can be held as retrospective by virtue of section 154, because the ultimate idea of the GST law is that you should get the credit.
Not a new tax levy.
Not a new tax levy. Therefore, you are proceeding further to further the provisions of the act. Therefore, you are making it retrospective, understandable. But if you are going to say that a law that is prescribed for the first time now, and in such a detailed manner where everything is defined, if that flows from the provisions as it was extant earlier, 164 enables them to do it, then I think we are looking at scope of 164, which was not even envisaged by the government when they introduced the GST law in 2017. Completely a new flip has been given to all this 164 and all that. Now you look at the amendments that were made, 2-3 slides there. To go slightly faster. Next. Yes. You see the definition that has been amended in 2023. Online, completely a new set of definitions introduced into the law. Online gaming means offering of a game on the internet or an electronic network and includes online money gaming. It's a means definition, therefore specific. Then online money gaming, this is the last expression that is used, that is again specifically defined. Online gaming in which players pay or deposit money or money's worth, including VDA, in the expectation of winning money or money's worth, including VDA, in any event, including game, scheme, competition, or any other activity or a process, whether or not its outcome or performance is based on skill, chance, or both, and whether same is permissible or otherwise under any other law for the time being in force. There's nothing that has been left to doubt in this definition. Every possible argument of a trade has been taken care of. When they're entitled to it, they have done it. One. Then specified actionable claim means the actionable claim involved in or by way of betting, casinos, gambling, horse racing, lottery, online, money gaming, etc. Then you had the definition of next phrase. You have a definition of supplier being introduced. Provider. In relation to goods or services shall mean the person supplying the said goods or services. And the proviso, a person who organizes, arranges, directly or indirectly supply of specified actionable claim, including a person who owns, operates or manages platform, shall be deemed to be the supplier of such actionable claims. Whether such actionable claims are supplied by him and whether consideration in money or money is worth for supply of such actionable claim is paid or conveyed to him or through him or played as in disposal in any manner. Practically, the entire activity is taxed in a different manner.
In the hands of the platform.
In the hands of the platform.
Okay.
And you are entitled to do it. Whether you are right in saying that the full face value has to be taxed or not is a different situation. But you have considered him to be a supplier. You have considered the activity to be, which is supplied by him to a supply of an actionable claim. And you have said that this will be taxable as your tax online games. You have said everything.
It's a deeming fiction.
Deeming fiction. And you are entitled to put it as a deeming fiction. Having done that in 23, can we say that this is clarificatory in nature? This was always what was understood by the trade, by the department, by the law, by the parliament from 2017, which is what is slightly concerning as we go further. Yes, please. And Schedule 3. This is the amendment that took place. Activities which shall be treated neither as supply of goods nor a supply of service. They said actionable claims other than specified actionable claims. They amended the entry of section 6. And simultaneously, they added 31B. Value of supply in claims of annual online gaming, including online money gaming. Notwithstanding anything contained in this chapter, the value of supply of online gaming, including supply of actionable claims involved in online money gaming, shall be the total amount paid or payable to or deposited with the supplier by way of money or money's worth, including VDA, by or on behalf of the player, provided that any amount returned or refunded by the supplier to the player for any reasons whatsoever, including player not using the amount paid or deposited with the supplier for participating in any event, shall not be deductible from the value of the supply of online money gaming. Can you ever have a rule that says that a deposit that is made will never be deducted? It will be part of it, and you treat it as value of goods. You're treating it as value of goods. And the expression used is that it's a money deposited. Deposit in terms of section 15 says it will never be considered as a consideration unless it is appropriated towards the value of the goods. So therefore, it was argued, look at 31B.
Rule beyond section.
Absolutely. The court says no. It is always inbuilt in terms of section 15, and therefore it is not delegated legislation going beyond the parent provision.
All these amendments happened after the Karnataka High Court order in May 23.
Karnataka
I got like
order was, it was happening parallel.
I think it was as a result, sir. Clearly.
No, the investigations with the Gameskraft started somewhere in 22. The discussion with regard to how to tax this betting and gambling, including online money gaming, was under discussion by a GOM constituting 21 onwards. In a way, fair to government, the entire taxability was in doubt, and therefore it was referred to the GST Council. The GST Council said, let this be examined by a GOM. And the GOM, while it was examining this issue, this investigation with regard to Gameskraft started. And initially, they filed a writ petition with regard to some investigation where deposit or bank account was attached. And subsequently, I think that was challenged. Then the DGI came back and said that we will issue a notice. The entire process happened parallel. It was not consequence to that.
Okay.
I think we should.
Actually, in 2023, when the amendments were carried out, the decision was made They have supplied the copy, signed copy.
In fact, that October 2023 decision to implement it from 1st October was taken in the July 2023 GST Council.
That is what all
But sir, Karnataka High Court decision came in May 23, sir, if
Yes.
I'm not wrong.
Right. It was.
I thought it is more of a fallout, and the way they worded the amendments, it is the
there are-
arguments taken by the Gameskraft and the taxpayer.
Two things were there. Two things were there to be fair to the government also. The if you look at the 51st GST Council meetings, and then the 142nd GST Council meeting,
47 GST
47
Council.
GST also started this process that we want to tax the online gaming. We want to tax it as actionable claim. We want to amend the definition of actionable claim. We want to treat it as goods, and we want to provide a valuation mechanism.
Another full bet value.
On full bet. That's the
Even on the valuation aspect.
originally when you look at the GST Council meeting also, this
They're all
discussion was
available.
there.
It's all available.
Okay.
This is there. So therefore, the GOM, as sir is pointing out, also looked at it and made a comment, made an amendment, and made a suggestion. See, you can have a GST Council making a suggestion. There's no problem on all
It
that.
did not crystallize into a law.
Law at that one. Two, let us assume that they have it is treated, and then it is ultimately the rule is framed in terms of the GST Council meeting. That still does not mean that that rule has to be examined without looking into the parent section.
No, absolutely. That goes without saying.
You may have a method of examining it and you want to do it. That's different. But then to say that because of all this 31 is in terms of section 15 is what seems to have a problem. That is where the problem is. I will go to the key findings directly. Some 3-4 slides. We had RMDC 1, RMDC 2, then Jungli, all that has been examined. So all of them were under a different, Jungli was on a different point. Anyway.
I think unless somebody reads through the original judgments, then read this judgment in Gameskraft and Jungli games, they'll not get the entire
picture.
essence of this.
Absolutely.
Because here what Honorable Supreme Court has done is extracted some of the key observations in RMDC 1, RMDC Narayana, and in the discussion and K.R. Lakshmana. But more importantly, when it came to the findings analysis, they've also referred to MG Shivani and all those
But
things.
RNC 1 and 2, they have discarded the argument that game of chance and game of skill will have any kind of a difference when betting, when their money is staked.
In fact,
Just to rule only that they have referred to, otherwise that they did not rely on that.
in fact, if you look at RMDC 1, the only point we can take is it was with referred to the Bombay Price Act, Competition Act. It was with regard to the taxing power. Not so much with regard to entry number 34.
Absolutely.
Now, the doctrine of severability, which was talked in RMDC 2, also brought in along with the taxing the regulatory power of the states in terms of entry 34. Now, somewhere, in this entire process, like what Shivdar sir has mentioned about, the taxability remained excluded as an actionable claim because sale of goods did not cover. In the central jurisdiction, because you had no power to tax goods on retail sale, while carving out the services, we are very mindful of the fact that the entire value of the actionable claim should not get taxed because it's beyond the legislative competence to tax a transaction in its generic where it cannot touch that value. Like, for example, if you look at worst contract, we always provided a abatement because worst contract was a deemed sale under Article 360-29A. I would not have had the power to tax on the services. So the same rule.
Now let's look at the findings of the Supreme Court. First, that is, you start off in a particular manner and thereafter you said, in view of whatever we have discussed, in any case, it's not relevant. That's the way the process has gone. You look at this. A game of skill is one in which the result depends primarily on a person's ability to significantly influence and control the outcome. There is an element of uncertainty in every game, whether it is game of skill or game of chance. While determining the outcome, if the ability to control is insignificant when compared to uncontrollable factors, the game ceases to be a skill-based one and becomes a game of chance. When stakes, now therefore, this is one, first three findings are giving you some leeway on how do you decide game of skill or game of chance.
The proportionality.
Proportionality, and then the extent of control you have on the outcome, etc. Now you look at the next one. When stakes are involved in any game, whether it is played by a spectator, participant, or the player itself, it assumes the character of betting and gambling, regardless of the fact that the game is skill-based, chance-based, or a combination thereof. The moment you put in money, whether it is skill, whether it is chance, all that is irrelevant. If that's so, the only thing that should have been seen is, are you putting in money? Since you are putting in money, it's gambling, full stop. Nothing beyond it. There's no need to get into what is the underlying factor, what is going to be skill, game of skill, game of
This
chance.
is a fair proposition that where stakes are involved, it is beyond skill or chance.
May be right, may not be right, it's a different point.
Sir,
What I am saying is,
many years that we lived with the difference between game of skill and game of
It
chance.
is not.
Suddenly, with one word, you say that the minute money is there, that there is no difference. How you can overnight change?
Putting the money is like an entry fee.
absolutely.
I'm putting it to participate in the game to win. So it's whose activity it is. It is
Absolutely.
not the
I paid
platform's activity.
I play a game of cards just for entertainment because he's providing the space that I'm paying an entry fee for it.
So whose
That is
activity?
the platform fee, no, sir. But over and above that, what Shivdas sir said, 200 minus 20, 180 is the betting amount, right?
Sir, whose activity? it is?
Betting is not there. Then what is the situation?
Suppose I lose 180.
Then what do you
You
do?
are looking at it from whose perspective? You are looking at it from a platform's perspective. You are looking at it from the player's perspective.
Players first.
From whose perspective?
Player.
By players,
Therefore,
But the Supreme Court has said that the platform is the service provider.
That's the definition you provided in 23. See, what I am saying is you
Yeah,
provided.
the judgment was made in 23 before the amendments. So now that we have got the 417 pages of judgment now, but it was made, that it's decided in 23.
That may not, because hearing itself takes place in 25, and that may not be fair and all that, but otherwise.
But they have put all that, the skeleton was framed.
There
They
has
have
to,
put the
there has
flesh
to
and
be
blood.
also a point which we need to consider when you read the judgment very carefully. When a competition entry fee has been paid, right, in a tournament or an organized event, etc., the Supreme Court has also clearly acknowledged and incorporated in the judgment that this is actually not a betting and gambling. The moment that entry fee is actually linked to an uncertain outcome, then it characterizes into betting gambling. So long as that uncertain outcome is not there and there is no stake, and that stake, if it is only as a form of an entry fee, for example, if I'm conducting a cricket match in Chinnaswamy Stadium, I say for every person who wants to witness this cricket game, I will charge 100 rupees as a fee. Now that 100 rupees as a fee is for admission into that event. It will continue to qualify as a services as per the GST law as well today, right? Now, that money collected on 100 rupees from, let us say, 1,000 spectators, it turns into a corpus money. If the price is actually paid out of that proceeds, then it's a different proposition. If price is given as a nominal money,
Sir, what is nominal?
that's what I said. Now, this is very clear. If I'm giving a trophy, for example, for a winner, now the club must have thought it, okay, I'm conducting an event. In my overall scheme of things of conducting an event, I have to award a winner. I give a prize money. You may give me a plaque, you may give a money worth equivalent to a cup. There, the Supreme Court has very clearly said that entry fee that has been collected will not be considered as a money stake. I think you need to be very mindful of that observation.
I don't know, sir. The IPL itself will be now at stake.
Right. All those things will come. I'm only making a point what Honorable Supreme Court said, that it is not that it has equated every compliance entry fee as a stake for the
Betting or gambling.
betting gambling. It has also said that.
Now we go to the state of validity of 31A. Or consideration, sorry. Before that, consideration. Only 3 more points on this. Now look at the findings on consideration. In betting and gambling trends, so you have already decided that there is a supply of an actionable claim. They've already decided that actionable claim is goods. Therefore, there is a supply of goods. They've already decided that there is a platform. The platform fee is the person managing the platform is a supplier of goods. So all this you have decided. Having decided that, you now go forward to decide what is going to be the consideration. You look at the way it is being written. In betting and gambling transactions, the stake amount is paid for participation in betting and gambling and for acquisition of the actionable claim interest. Even if at a particular stage prior to participation, crystallizing the amount may retain attributes of a refundable deposit, the character of such payment fundamentally changes once the participant is admitted into the betting or gaming arrangement and the amount stands appropriated towards participation in the underlying supply. Upon such appropriation, the payment ceases to retain the character of a mere deposit and forms part of the consideration for the supply involving actionable claims. What is the actionable claim? Of the total 180 rupees. When is the supply of actionable claim taking place? After I play and then what happens thereafter? If you say the moment I enter into an 100 rupees I deposit, there is a supply of an actionable claim and therefore on the entire 100 rupees I am supposed to pay tax, then that is far-fetched. GST is not concerned with the subsequent way the supplier may utilize, distribute, or account for the consideration after the supply. GST framework ordinarily proceeds on gross valuation and not a net-based valuation mechanism unless specifically contemplated by statute. I really did not understand what does it mean unless specifically contemplated statute. Statute itself says you should pay tax only on transaction value.
And all that 15.2, 15.3 will become
practically redundant, sir. Practically, you are diluting the rigors of section 15.1, 15.2, and by virtue of this judgment. Once an amount stands appropriated towards a supply and enters a statutory valuation mechanism, subsequent distribution or retention of the price pool would not reduce the transaction value without express statutory exclusion. The value of supply under section 15 is thus intrinsically linked to the amount staked towards participation, and staking constitutes consideration paid in respect of and for inducement of the actionable claim supply. This is what, sir, they have said about the consideration. Now you look at what they say about delegated legislation or 31. They say a reading of section 15.4 where value cannot be determined in section 15.1, 15.5, definition of prescribed indicates recommendation of GST Council is required. Regardless of whether 31A traces its source to section 16.4 or 15.4 or 15.5, the statutory requirement is fulfilled. 31A3 was found under the recommendation of GST Council. Agenda number 51 dealt with value of supplies of bets in horse racing. The agenda framed by the Fitment Committee was approved by the GST Council. Section 15.5 applies to notified supplies, which may require specialized valuation methodologies having regard to commercial structures and practical difficulties. These methods operate independently and without conflict with section 15.1 or section 15.4 and must be read harmoniously to give full effect to the statutory valuation framework. That means in every case, this can be used to say that, no, we are trying to do this. Therefore, you are giving a handle to the administrator to say your valuation is to be rejected. It is good enough for a notice. How ultimately it happens, that's a different point. These valuation methodologies are matters of legislative fiscal policy, and the legislature has latitude in devising standards so long as there is a reasonable nexus with the underlying taxable event. This is what is slightly next.
Next slide.
next slide.
The phrase cannot be determined and used in section 15.4 cannot be interpreted narrowly to mean that the rules for valuation would apply only in cases of absolute impossibility. That's the law. The provision extends to situations where uncertainty exists regarding valuation, divergent industry practices, or clarification is required to ensure consistency and uniformity. Independently of section 15.4, 31A is sustainable under section 164. This is what, as sir was pointing out, when the notification under which 31A by itself doesn't say it will be retrospective. It doesn't say it will be effective from a particular date. To say that, yes, we will make it retrospective by virtue of a section 164.
No reach.
The absence of a notification section 15.5 is not relevant as it operates independent of the ordinary transaction value framework, and 31A can be traced to both 15.4 and section 164. So that is how they uphold rule.
And incidentally, I think rule 31B and 31C starts with notwithstanding anything containing.
Absolutely.
Non-obstant. Clearly, in a way, I think, irrespective of the operation of 31A, we are prescribing as prescribed methodology for the valuing supplies, online gaming and casinos, which is notified by virtue of 15. So this observation, what Sivadas sir has last read, is to give the legal sanctity for covering the valuation 100% value on bit value in terms of the rule 31A, which remained in the statute book from 2018 onwards.
So now, with this, now let's look at what is going to be the impact of this decision going forward. So practically the Supreme Court has upheld everything relating to the taxing of a taxable transaction.
You can keep it aside.
First, there has been a dilution of the relevance of distinction between game of skill and game of chance for the purpose of taxability. That's gone. Unless the Supreme Court again looks at it and says, no, this distinction has to be maintained, because all the earlier decisions about RMDC 1, RMDC 2, Lakshmanan, all of them talked about the essentiality of the difference between the two. If you want to dilute it, then there is a necessity for the Supreme Court to relook at it. Number one. Two, clarificatory nature of 31B and 31C and its retrospective applicability. When the notification itself did not indicate that the effective date was retrospective, can courts artificially recast the effective date? This is going to be a challenge if they want to use it in certain other cases. We don't know which case they can use, etc. They can come up with any situations. Then 31B and 31C are levy provisions which take into consideration the entire amount deposited rather than actual betting amount and not mere valuation mechanisms. Whether other transactions purported to involve taxable and non-taxable portions can be looked at a composite activity. In fact, as what one comes to our mind is this corporate guarantee, as sir was pointing out.
Even I think the brand owner surplus could come in.
Also come into this, absolutely correct. So therefore, if in a corporate guarantee, in fact, we are seeing some show cause notices where corporate guarantee, the consideration is not in terms of what is agreed as the fees that is paid, but in terms of what was the amount that was originally lent and what was originally stood as guarantee, and thereafter how much has been reduced because you paid up the loans or something, how much remains. They try to net off saying that this is the difference, and for the difference you are supposed to pay. That can never be a valuation mechanism like that. So can all that be brought under this method? Whether definition of consideration can be overridden by a valuation mechanism prescribed by the rules. Treatment of deposit made at the entering of the online framework as a consideration, where similar interpretation can be applied for other deposits because the actual supply event. That is going to be a big challenge. Of course, way forward, all these notices I see from the orders, it's invoked to section 74 as an invoke. That plainly cannot happen. Section 74 and all cannot invoke in this case. But even if you say 73 is applicable, 73 can still be a good. We are only in all these notices are of 24, 25, 26 and all that. So therefore 73 can still be applied. And we cannot argue today that 23 amendment is prospective and therefore only from 23 it should be held. That's not possible unless Supreme Court re-looks at it.
Otherwise it's 141.
Otherwise 141. Therefore you look at say a notice issued in 25 going up to 3 years, which is 2022. Therefore, even if 74 is not invocable, a 73 demand can still apply in respect of these cases.
The pre-amendment period.
Pre-amendment period. And can the stands under wagering contract being void be considered as an actionable claim under TO be relooked at? That can only be done by the Supreme Court. Aspect of non-levy of tax on advance of goods, whether that can have a problem because your time of supply is being pushed to the actual activity instead of initial deposit. That also can have a problem for situations where companies provide advance for goods that are being purchased, etc. Whether those and all can be an issue unless, of course, notification is still there or notification is not there, then what happens? These are all some of the challenges that can be there in this.
So prior to 23, first 3 years, can I not claim shelter under 128 capital A amnesty scheme, although the deadlines have well passed? Is that possible?
Because the
Timeline has passed.
unless you go to the Supreme Court and say that you have made me responsible for that.
Exactly. So I should be, if given the benefit of 128A.
Supreme Court says that you can't get the benefit. You should again go back to Supreme. That happens in most of these Kar Samadhan schemes and this.
Yeah. If there is a retro Supreme Court ruling.
We use Supreme Court.
Even the tran one also, the Supreme Court, the courts have held, government opened the portal and then gave opportunity for complete reconciliation and verifications. On the direction.
It's a good case to go nonetheless to Supreme Court if you want to take shelter of 128.
It's a good case to go to Supreme Court on all the points.
Of course. I mean, this is the legal part.
So thank you, sir. Thank you for your for walking us through the entire ruling in your way, as you always do. Thank you, sir. But essentially, the way I look at it, there is a confusion. There are unanswered questions. There are answers which we possibly don't like.
There's an international player and he remits foreign currency, presuming the RBI rules. I'm just putting it. Will the platform be required to discharge reverse charge because they purchased the actionable claim?
So when you are supplying an actionable claim, it will be considered as you are a provider of an actionable claim. It's quite possible.
Section 14A of the IGST Act has made a very clear-cut carve-out that online gaming companies providing gaming to an Indian customer, they are not the Indian customer being a non-business person. Earlier, there is to be an OIDAR obligation which has to come. That is how this entire thing was looked into this pre-GST period. Now, in order to set the level playing field with the domestic game providers and the foreign game provider through the platforms, the section 14A has made very clear. Actionable claim is goods. So therefore, it will come under the purview of the customs, not the reverse charge in the Schedule 2 by deeming a service. So what they did was, under Custom Tariff Act, an amendment entry was made in 98.04, the chapter 98.04, where project imports were there. They specifically included actionable claims into that. And by virtue of giving a notification of 18% applicable or 28% applicable across any chapter of the goods, they've taken care of it by virtue of that.
So I have a
Accepting that, you'll have to pay customs duty on the.
No, I got it.
And the basic custom duty is there.
Basic customs.
Basic customs.
That will be.
Sir, I have a question. See, while we are debating on the pros and cons of this judgment, betting and gambling per se is now banned. It's illegal.
In certain states, not everywhere.
The law enacted by the parliament is.
Now what happens is there is a slight flip to it. Now, if you say the moment you say this is equal to betting and gambling, then betting and gambling, even today, the law to regulate it remains with the state.
Entry number 34.
37. Therefore, that law made by the parliament, therefore, can now be open to question before the courts.
But it is now, the rules were also framed and it is effective from 1st May 2026. It is notified.
Okay, but that was before the Supreme Court decision saying it is equivalent to betting and gambling.
Now what is the
That can be open to question. The states will have the liberty to frame laws. Like your this thing was Jungli was in respect of a state enactment trying to regulate. States will have the power to regulate it. Center may not be in a position to do it. That law can now be open to question.
Like your labor laws, the model law has been enacted, but implementation with regard to how the labor codes will be implemented in terms of the rule making, the states have been given some amount of.
The center has notified the rules.
Correct.
And this
That power will be questioned.
That power will be questioned. The law itself will be questioned now. That's what you want. States can now do it.
The mess
Some-
will continue.
Yes.
No. This
Regulatory part.
Regulatory part, not.
Tax laws are very, very clear, Santosh. I think
But what will
In
cover
the
is
judgment that they have differentiated between these two, regulation. tax doesn't have-
FDI will not be very easy because it's a central law notification. FDI comes within the framework of a central law. FDI, which was earlier allowed for a game of skill, that will now get confronted because of the central government notification.
So what you are saying that across India, because it's a parliament law, anyway, going forward, it is not there.
We'll take that.
So
So not to get into the
But we
legal
state-
aspects, just for the next 2 minutes, like you said, if I start with 100 rupees, then if the rate of GST, the levy of GST is on the entire 100 rupees every time I kind of circulate that, then clearly winner is the government, sir. See, because arithmetically, if I start with say 100 rupees at the beginning of the day, and I assume my stars are extremely good that day, I win. I win average in card games, I believe, is about 1.5 times average if you take for the full day. Suppose I play 4 rounds, and if I stand to win in all the 4 rounds, where I win, I put the entire money back, I win, I put the entire money back, I will probably walk out with 74 rupees at the end of the day. I have won all the 4. No, arithmetically, I have won all the 4 games as a winner. Okay, I have got 1.5 times. But at the end of the day, arithmetically, while I started with 100, I walk out with 73 or 70.
You have introduced that 130
Yes.
again. I've got
Yes.
that. So
Yes.
that is
So
one-
every time I pay 28% for the past period, clearly the winner is the government, sir. Winner is the government in this, not the player, neither the company. Sir, there is one more thing in what you mentioned, sir. You know, the difference between goods and services. You know, if I go to circular number 27 of 2018, government has said, you know, in question number 2 and 3, that betting and gambling is a service under 9996
Correct.
and full face value of the bet is taxable. While circular says services, the amendments are with respect to actionable claims that it is goods. And today even Supreme Court says it is goods.
No, that was pointed out to the Supreme Court in this decision also, saying that there is an entry 99 etc.
9996.
Says, to a department says this actionable claim, it is treated as goods. Once you say it is services, how in the same breath you say it is goods?
Absolutely.
Supreme Court says that
You can't appropriate and
classification, etc. and all is irrelevant. Supreme Court says your SJC, SAC heading and all is irrelevant. That's only for the purpose of statistics. We have held it is to be goods. Therefore, whatever happens, it is to be goods will follow. The fact that they have issued a notification to say that it is services, etc., it doesn't go in for a determination for the purpose of actionable claims.
Sure,
So
sir.
Supreme Court has
Sure.
rejected that.
So just one more thing, possibly to Mr. Shivdas and Mr. DPN, both of you. Sir, each game is different, even within card games. And when I compare card games to what happens in a casino, etc., each game is different. Sir, if we take a lottery for an example, which has historically been actionable claims, it is taxable as goods, etc., etc. There is a person who is organizing the lottery. It is quite possible that an unsold lottery also can be a winning ticket. That time what happens? There is no winner at all. The entire money which is being collected is retained by the organizer himself. That is what happens in a casino also to a large extent, because I am playing against the club only or that casino. It is possible that nobody wins in a roulette, in a poker, etc. It is possible that nobody wins. But if you take a card game, which is like a rummy, I'm not getting into whether it is a game of skill or a game of chance. There is no way that there is no winner. There is impossible there is no winner, right? So how do you look at that? Because there is another activity which is chit funds. Very clearly, the commission retained by the foreman of a chit fund is what is taxable, not the entire money which I contribute as a chit in that month. How do you correlate these two, sir? Sir, DPN sir.
I think we need to clearly understand one thing. You talked about an example of lottery. You talked about a chit fund operator.
Yes.
Where the valuation is very clearly defined to be what exactly is, in case of lottery, it's the come tax value. On the distribution commission, service tax was being levied. Post the GST coming into that, this issue went up to Skill Lotto. And Skill Lotto very clearly said the measure of levy can be left with certain leniency to the legislature. On the entire face value of the lottery ticket, you'll pay 28%.
Absolutely, sir.
Now, in case of a chit fund, the foreman commission continues to be the commission or
Only the
million.
commission.
in online money gaming, by making the online money gaming as a supplier of service, if you read 105 proviso, it only covers online money gaming and it doesn't cover lottery, it doesn't give casino. Am I right?
Correct.
Yes, sir. So to that extent, the carve-out will take care of this prospectively.
But sir, the fact all remains that there is no money that is retained by the club or whoever the organizer
No,
is.
but
online
I
money.
think what they have said, as Sivdas sir has correctly said, by creating this friction of a supplier, it is either through deposit or every possible, the moment the money is deposited into a platform, irrespective of the fact whether it is retained a part of it for the platform for its commission, including the expenses, or it goes to a price pool, the entire deposit is considered as a transaction value by which you offer consideration deeming, because he is a supplier. The moment the actionable claim is actually created and supplied simultaneously, there's an argument which went into this court also. They are considering that who is the supplier of the actionable claim. It is not the player, the platform.
It is the
Because the Supreme Court
it is the
reasoned out
organizer.
that you have a control over it. And it is also discussed at length how this deposit could be used for inducing in terms of discounts, price additions and incentivization and all. So you are not, when you make a deposit, it is a deposit in the name of the depositor, but withdrawal is not subjected to an easy option. There are many conditions attached to it.
Sure. Sir.
And in a way, I think the revenue has argued to say that the deposit is something which can be applied to a game, which we all understand in normal course, but that deposit can be used for many other purposes. Today, one of the things which the online gaming company has done, you can even use that money not only for playing games, but also for giving some goodies in terms of the gifts, tangible items, etc., etc.
Yes.
Therefore, it is actually the assumption that the entire control on that money which is in the wallet is with the person depositor is not correct entirely.
Another thing is ICA describes the guidelines how the accounting entries have to be made. Now, as per their standards only, these must have made their account and the stat auditors must have certified their books. Now, the Supreme Court is giving a twist to the whole thing. They say that the entire 100 rupees is their income. So what happens to the stat auditors?
They have discussed about accounting standards also.
So are they going to
They
change?
say the fact that the platform operators account for it in a particular manner does not necessarily mean that they will be liable to pay tax only on what you net receive.
That the Supreme Court has twisted good in order to achieve their end objective, because it was set in 2023 itself. So they have achieved the
Very
goal.
clear on that.
So that is fine. But what I'm saying is that the ICA has to take any action now to introduce.
No, it will be
saying
the
that
ICA. The
ICA,
does it
for
or-
example, lease transact, finance lease transactions. It's the owner differently.
You are worried about Rajesh exports. Something like that.
Whether
Inflating of the
ICA
term.
revises its standards or gives a different set of accounting standards is a separate aspect of it.
And today we don't have a tax accounting standard for any of the VAT or GST. It applies to the direct taxes. Correct. We don't have a tax accounting standard. For example, you look at Rule 30 of the CGST rules. It talks about the cost of provision of goods or services. Cost of goods, we all will go through this erstwhile CAS4 and what Ind AS has given today. On services, we don't have an accounting standard at all. Still an attempt is being made. But still the law mandates that it should be cost of provision.
The Income Tax Act requires deduction of tax on the net amount of consideration which is paid under the Income Tax Act. And there, the platform is treated as an intermediary under the Income Tax
So you that understanding will go for a toss now.
That's why I'm
I'll tell you, after the amendment of 2023, where there is a deeming fiction created in GST law to say that you are a supplier, the treatment of him as an intermediary in any other law may not have much of an impact. Because in GST law, they have created deeming fiction unless you challenge the deeming fiction. But the law is created that you are considered as a supplier. So therefore, you may not be an intermediary, you may be an intermediary in the sense of your commercial understanding, but for the purpose of GST, they treated you as a supplier. That's fine. That's not a problem.
So the same transaction and the same person, all the direct taxes will be continues to be intermediary.
Maybe.
Because the deeming fiction cannot be
Possible.
The parties are
beyond its
Possible.
But the parties are different. You collect money from set of individuals or players, but you pay only to the winner. The net amount which is so the party to whom the GST is applied is different from the party to whom the consideration is paid under the income tax.
Absolutely. Absolutely true.
They may be identified as one and the same, but they come in two capacities. One as a participant and one as a winner.
That's true.
That is possible. That is possible.
So just an add-on to what DPN sir mentioned. While the law is the way it is, the definition of online money gaming, nothing is left untouched there. Everything it considers. But the aspect that the company or the organizer does not earn anything, it is not his money at all. Should it make a difference, sir?
According to
Legally?
Supreme Court, no.
No.
According to
But-
Supreme Court, no. No.
And you're disappointed with the judgment.
If you ask me, you say it's something like this. No, you're asking me to pay income tax on what? My income, no. You don't ask me to pay income tax on
What I don't earn.
what I expected to incur. Even an advance tax will ultimately get adjusted towards an actual income which I receive.
Hmm.
You don't anticipate an income. It's not a presumptive taxation in that sense. Therefore, you will have a
Done.
problem there. Then
Done, sir.
Supreme Court says that's not relevant.
Specifically there.
Sir, PVS sir, one for you. Sir, the notice for Gameskraft was 21,000 crores. Now I'm sure it is much higher. For the subsequent years and with the interest that has got accumulated, etc. And Gameskraft is not alone in this situation. I'm sure there are multiple. There are at least 1,000 companies who've been doing online gaming.
1 lakh crores or something.
2.5 lakh crores.
1.5 lakh crore is the
Sure.
The
Sure. that one.
official figure is 1,12,000 crores. Is that estimated liability will be 2.3 or 2.5 lakhs, including
2.5.
interest and penalties.
Including interest.
From a business perspective, how do you see this, the possibility of even recovering this, sir? I'm not getting into the subsequent show cause notices, assessments, etc. Now, Supreme Court has said whatever it wanted to.
Court has given an indication that this actionable claim is an intangible. Money has gone, money has gone, come and gone, money has gone. It's an intangible asset with which you are dealt and is emerges and perishes the same time within the game. So it's not sustainable perpetually. Actually, barring some small assets like computer servers and even the building will be for rental. So that's nothing to recover actually.
Sir, but I will add one question to what.
Sir, but,
For amnesty scheme is law.
Yeah.
No, amnesty scheme is
There's nothing to recover.
No,
What
even in an amnesty scheme, there should be a possibility of recovering at least the basic tax.
There's nothing to
That is how
recover
amnesty
because
scheme is.
it's an
brought in.
intangible business. It's only an intangible business, barring some kind of an asset like software, which may have some intrinsic monetary value. Beyond that, there's nothing in there.
Sir, what about
One point to add to what Badri said, Badri's point and what you're answering, sir, is that the cascading effect on the promoters, directors. if the
In
company
terms
is
of
put into
partnership
insolvency-
firms, we have to look at the nature of the person. Partnership firms, the liability will travel to the partners. In a company, private company, it travels to director provided he has participated in a way that he stops the recovery. So nobody is going to stop recovery because nothing is there to, they will all cooperate to hand over whatever is left and say, please collect it. So that non-cooperation will not be that much. We should advise our clients if we have some clients that please hand over whatever you have.
Sir, in fact, we will travel this question from you to DPN, sir.
Answer.
On 11 years. 11 years, sir. Now, does this create a compelling case for 11A? The industry-wise interpretational, maybe an exception, can that be looked at, and is there some relief that the industry can look for? Can that be a thought with the government, sir?
It's too early to say anything on this because what happens today, we have by a general practice, it has not been levied or collected, or it is short collected or short paid. The law provides for it. So if industry could make a representation and convince the government, it is by a general practice and understanding of law, they paid at a lower rate of 18% and not at 28%. Does it qualify to be a request before the government for 11A? I think the enacted law provides for, by general practice, if a tax has not been levied or collected at a rate much lower than the rate otherwise is applicable legally, which is 28%. Then the legal framework could cover, but let me also hasten to add, it's too early to look at because Section 11A has not been, it's just been notified in 2023, operationalization happened. Not a single case has come before the government under Section 11A so far. And this amount involved is substantial. And more importantly, the government will be very mindful of the fact that it has been approved by the Honorable Supreme Court. Of course, the Supreme Court has interpreted the law and given a ruling, and therefore the government would actually has to weigh all the scenarios before even looking at a possibility. But it is not beyond the realm of the government to have a relook on the whole thing, considering whatever the challenges you have all expressed. Look at the AGR as a pointer. 2019, the Supreme Court said whatever the Department of Telecommunication has communicated as a quantifying in terms of the interest, the penalties, the interest on interest, etc. The Supreme Court said exactly the calculation is correct. But in the year 2025, when actual payouts were to be started, the industry felt it is just not possible for continuing the business. There has been a decision, you're all aware of that. The options were given to those companies either to convert a part of the tax dues into debt, the calculation dues into debt. Some of them opted for it. And even after that, there has been a challenge in terms of the repayment. The repayment has been restructured. Government can do, and the Supreme Court clearly has said that that's in the realm of the government.
But the AGR views, it is a nature of service which is economically contributing. This is viewed as.
This is one thing which I want to tell. I think I am glad Mr. PVS brought it. The entire thing when we talk about betting, gambling, alcohol, etc., these are all res extra commercium, and there is no economic rationale or a societal interest involved to say this need to be treated with compassion. I think the rest extra commercium will be a greatest impediment even if the government wants to do. The question will arise.
Another Azadi Pacha will go to the Supreme Court.
See, to me, this optics for the government will be against them to do anything on leveling.
Secondly, having issued a central government act now, which is exactly wants to not the business to continue.
It's too early for us because, when we have looked at fiat judgment, when Supreme Court gave, or for that matter, when we had the other Northern operating, there was
just all cases,
reason.
As sir pointing out, fiat was a genuine case of interpretation. No malefides in that.
Yes.
And the whole thing is not looked at with a negative connotation.
Right.
If you look at this decision, immediately after the findings start, about 8-9 paragraphs on the morality of the sector. That's how they start. And then towards the end, they also said that just because they are using advanced level of technologies doesn't mean that the damage to the society should not be looked at by the courts while looking at the taxing of loss. I mean, where does all this come into an example?
Sir, somewhere that has gone into the retrospective applicability and the valuation. I think
entire decision.
They've come down very heavily, more I think on the morality also.
And that is the context in which when PBS said this, the whole thing is 11A. 11A will have to have a lot more convincing to the government that, like immediately when we said about AGR, this is something which government expected that there should be more than competition. There can be duopoly, there should not be monopoly, there should be more players. Telecom should be affordable, and there is a lot more government intention to create a competitive ecosystem so that the consumer ultimately gets benefited. All of these factors worked into when the scheme was reworked with the government. In this case, while government can come, 11A can come, amnesty can come, but is there will there be a sufficient appetite on the part of government to take that? It's a big question.
Only one point I'll add.
If the government, we should also be very happy. All of us should be happy if the government comes out to the circular saying that there are observations of the Supreme Court on the applicability, retrospective nature, etc. All this will be confined only to the facts of this.
Like the way they have clarified in Northern
operating, and it cannot be applied generally for other cases.
Northern operating, the Supreme Court itself said.
Therefore, if they do that, then that would be.
Westinghouse came out with a circular. Westinghouse they came out with a circular. Customs.
Government has been already.
That is being done. If they do that, that will be the best that can happen in this matter. Even to do that also will be quite a challenge for the industry.
Sir, PVS sir, how do you see this kind of have an implication in the sense legally from a business perspective, both for these, esports? I'm not talking about card games or the sin games as DPN sir mentioned. I'm not talking about horse racing, casinos, etc. More say cricket. There is an element of betting. Like sir, when we were coming to BCIC today, sir raised one more point. We'll take the answer from him only. You know, it is like today, if an investor is putting in money into a company, into a startup also, that is also contingent. That is also contingent. God knows whether, I mean, no one knows whether that will succeed or no. There is $1 million that is being put. So how do you see that? So we'll come to that. But in the meanwhile, sir, something on the esports, say maybe cricket or anything for that matter.
The investor, a promoter coming and putting money and then carrying on business, his reward is the business proceeds, goods and services which he sells are subject to tax only. So your logic doesn't actually doesn't travel.
It's capital money. It is more the investor money which is going in. Sir.
I think insofar as I think we need to be very careful about this. This judgment is only in the context of online money gaming.
Gaming is a limited.
It's an online gaming.
It has not even overruled the card
Yes.
game.
I
Not
think
even overruled the
Section Rule 31BC are very specific carve-outs for only for online money gaming and casinos.
That is because of
31A is also only for
technology
horse
being
racing and
employed to control
it
the
cannot be applied to
system.
general.
Noted, sir. It should not be. I mean, that's an important
That
takeaway
discussion on
actually.
technology also in the Supreme Court judgment is an intrinsic part of this judgment. That is a controlled activity. You control everything. And therefore, the element of skill and the element of chance is subordinated because you control everything, you know.
And for a taxing entry, I think the legislature or for that matter, the government is
So I will
completely at freedom to
the
decide.
judgment has been very careful. In my view, if there's a government clarification, well and good.
Well and good, yes.
Even if it is not, with some struggle, we'll be able to put it across at some stage that it applies.
And
only
at least
to-
the tax certainty is there now that this got decided so quickly is also a matter where industry should feel comfortable because 2025 hearings concluded and 2026 we have a judgment and the new law which has been enacted from 2023 gets completely approved. The clarificatory or the retrospectivity will go through the process, but probably this is already the final word as said in Supreme Court. So we should honor and respect that.
Very important, sir. Very important piece what you said.
Accepting that the industry should be there to be happy.
What about the possibility of challenging at a larger bench, 3 or a 5 bench?
And you'll have to go through the process. once again.
Esports framework is already formulated in the new government.
Industry will be there, no, sir.
True, sir.
You can,
Industry
there
will be
also,
there.
there also the last
Because
leg of it is that betting.
Finally, it will get passed on.
Even with the
Everything to do with this is going to be the
There is
people
one question I
who
will
pay the
take
money.
with
No,
DPN.
industry will be there.
One
How
question
will the industry
Please.
survive?
Sir, Venki has a question for you,
Your
sir.
past dues have to be taken care of first.
Right.
Now, if you are not able to take care of that past dues, how will you survive today? You're talking
Not
about
only that, even a new player, even if he wants to come and start his business, he doesn't know how to value his offering.
no, as the DPN sir is pointing out, other people who want to start their business from 23, they are certain that this is going to be my tax liability.
Correct, sir, but what is the tax? See, 100 rupees is the amount that he is taking. 10 rupees is the commission for the platform fee.
Correct.
So 90 rupees has to be distributed again.
Correct.
So how can you factor for a 28 rupees of tax?
The price
sir,
pool will come down.
Sir, one second. Sir, that is viability of your business, but there is certainty on the tax.
No.
That is the point.
That's right, sir, but how much he is.
Sir, don't-
That's a different argument.
Don't-
So 28 factor in, 38 rupees he has to
There's a-
reduce. 62 rupees will be the price money now.
Obviously, that's intended.
That's what he's saying.
This is the game of greed. So those who are
So-
greedy will participate.
Policy decision, prohibition versus collect more tax.
And if they want to ban,
It
they
will
will
be
ban
more viable.
from
Don't
the
worry.
government.
Government of ban.
No, sir, both are greedy. Government is also greedy and player is also greedy.
We have
The
to-
business will continue, the company may
Government
avoid.
has used
Different
taxes.
Absolutely.
See, we need to be very clear. Tax and equity are not the bedfellows. We should be very clear about it.
Absolutely,
And
sir.
secondly, look at exactly how the tax mechanism worked. Like Shivdas that talked about the MRP. You know, we had in excise regime around 40% is the abatement we have given. Government can choose to say that, okay, I will give only 10% abatement. Somebody cannot question that to say that it is irrational. So if you look at Bombay, the Supreme Court clearly said that, you see, in so far as the measure of tax is concerned, the leeway is given because it's for the public good.
Yes.
There's not a private gain. So therefore, in terms of taxation, in terms of determining the value, while we are all discussing very honestly that whether 15.4 can have primacy over 15.1, I think that's what Sarah has pointed out. That's a point to ponder. Now, within 15.4, a method of cost or cost plus something, the discretion is there so long as transaction value fails. Transaction value will fail when it is not the price paid or payable, or the transaction is between the related parties. Other than that, the 15.1 should always prevail over anything else. And that is a natural corollary. 15.2, 15.3 follows that what should get excluded, what should get included into 15.1 value in a price to arrive at a 15.1 value. Now, that is something which we can debate. But the power to prescribe a method of valuation in a situation like where even I would say 31B and 31C, where they have said even deposits would be construed as a value. That's the method in which the government has exercised the power, and the Supreme Court says that it's within the overall realm of the valuation.
That's why I said going forward from a prospective effect of it, the industry should be, that is especially the new players should know what they are supposed to correct.
There is no.
And at the end of the day, and the other side, if the government feels that, or the government and as approved the Supreme Court feels, by all this method, you are going to address a societal problem. Therefore, you are trying to bring down addiction. May not also work. May not also work.
Yes.
See, if I have to pay, if I have to get addicted, I will get addicted and I will pay that extra tax. At the end of the day, which business will try to retain the tax?
If you really want to address that issue, then prohibition.
Yes, that's the only way it can be done.
That will not happen.
If
So
that
I'll
doesn't
again-
happen, then this problem will always.
I'll again come back to the point, because see, today we are looking at future, whether things will happen. If we look at the prohibition law, the prohibition law has given dual powers to center and state. Center has been given the work to set up an online gaming authority, and the law clearly bars online money gaming.
Correct.
So today, online money gaming can never come back to India.
But taxing can happen even on illegal act.
Yeah, it can happen, but today.
That's one argument possibly could have been persuaded before the Supreme Court, that constitutionally it may be invalid, but taxing law anyway taxes illegal activity also. So whether it's a game of skill or chance is the only matter which needs to be decided.
Exactly. Not
Nothing
anything.
more, nothing
So
more.
you
Illegality.
should have decided that you can't dilute that and then go to an underlying purpose and tax the entire thing as gambling. That's a whole.
Somewhere, some advocacy could have been brought to the court that I concede that it is constitutionally illegal, but you are dealing with the tax law, and this is the principle for the tax law.
I just may be digressing. I think Bitcoin yield, the profits, if you pay 30%, it is white money. Otherwise, Bitcoin is illegal in India. But if you pay 30% of
Both of us tax. Direct tax tax it as a capital gain, and indirect tax collects this as a entire value on which the tax is being collected. And there is disputes. You see, for example, in a Bitcoin, there are three types of things. One is the discovery, that is taxed on the value at which it is being paid by the commercial exploiting the developer stakeholder to the developer creation. That's a discovery. The second is basically when it is traded as a consideration. Now, since it is not recognized by the RBI, it is not money or money equivalent for that matter. So the entire consideration is taxed again as a supply of goods. Third, when it is exchanged for a markup as a commission, the Bitcoin exchanges are being again taxed on this margin of profit which is collected. So we have been collecting on all the three things. While direct tax has been very clear, it's capital gain and 30% on the income whoever is acquiring this coins. But in indirect taxes, we continue to tax it in multiple phases: discovery, creation, transaction, and trading.
So,
for a margin.
One question, and then we can see if there is any online question. So, section 74, right? I think the larger concern with everybody is trying to, whether it involved in a gaming industry or not, right? Application of section 74 on a issue where there is an interpretation possible. I'm not going to get into whether it is a genuine interpretation or not, but interpretation is possible, especially when there is a high court order which is there. Of course, sir, rightly covered, it has to be adjudicated and based on the facts in each of the case. But can this be a standard for going forward, and how should industry look at to not to get into this tangle, because not everybody would want to go through this litigation process of interpretational issues 74 being applied. How should that entire application of 74, especially with the Supreme Court direction, be?
Actually, I think, Venki, this is a very important point. Compared to the pre-GST laws and the GST law, especially when we are talking about 74, we are talking only 3 elements for invoking the extended period and also the penalty. One is suppression, willful misstatement, or fraud, right? The intent to evade payment of tax is not an ingredient of 74. It is in 132, right? Now, Judha sir will be in a better position to say when an extended period of demand or suppression is invoked, is it a question of fact? Is a question of law? I think the jury is very clear. It's a question of law. It can be a mixed question of fact and mixed question of law, but courts have never hesitated in interfering, treating this as a question of law. Now, what I would say is, I think in this judgment, the Supreme Court has only laid down the principles and not get into the adjudication outcomes, be it somewhere where it was a criminal appeal and there are so-called notices which are stayed and then subsequently now freedom has been given to adjudicate. Now, these matters, there is no estoppel for the companies to raise this substantial point as a defense. To say 74 is not invocable because the ingredients of 74 in terms of suppression, willful misstatement, or fraud is not existent. It's a question to be adjudicated. And I'm sure, I think the appellate forums of the courts will not shy away from addressing this, notwithstanding this overall laying of the principles.
Wonderful.
That's the English saying, nah? If the flood water has gone above your nose, it doesn't make a difference whether it's 1 year or 5 years.
So left to the adjudicatory authority.
That's answered.
Yes.
That question online is answered.
Go ahead.
You can say 74 can never be invoked. You can say that. BCIC has said that.
Yeah.
In fact, there are precedents. In fact, NOS, if you look at that instruction which has been issued by the CBIC, the last para says clearly that mechanically section 74 should not be invoked just because Supreme Court said in NOS that it is actually a matter.
Even previous were discussing when we were coming here, saying that probably that could have been one of the points which could have been raised.
No,
They will not
sir, that means the arguing person will think that he is losing. So
yes, therefore he wants to argue. In any case, please don't consider 74. No counsel will say it. Even if you know 74 is
in this particular sector, Venki, all said and done, even NOS type of instruction will get issued. I have my own apprehension.
Only time this prayer could have been made is that
at the time of
judgment pronouncement. If somebody is very, very alert, they may say, since you are set retrospective, you can at least say the penalties and other things will be subject to 73. That much prayer could have been made, but it's a new prayer. It's not.
But I think, sir, to me, this matter will again come to the courts on 74. When arguing 74, this point of retrospectivity, etc., will be raised.
Correct. No.
Some court will find that maybe this should have been looked at in a different manner.
Correct.
It will go to the Supreme Court once again. Maybe a different bench will say, maybe we should have a relook at it.
But that is another question, because Justice Pardiwala will continue to remain till 2030.
Okay.
And he's going to become a CJI also.
So.
But will it go to a different bench?
No.
File a review petition?
That it will definitely. He himself will say that it can go to.
No, sir. We have to trust the institutions.
Nothing else you can do. It has happened also like that earlier. It had gone to one, it was pointed out, then he said not before me, it has gone to another bench.
I think we need to look at Supreme Court with a fair amount of things because we have seen how the decisions have been taken. I will just quote Canon judgment. Canon was a 3-member judgment with Chief Justice sitting as a part of the judgment, holding that the entrustment power given under Section 6 is basically the power for adjudication. We all knew that this decision was somewhere, we have not argued the case from the government side properly, and this decision has become 141. When we filed a review petition and the review petition was heard and it was brought back and the entire argument was done, notwithstanding the amendment which we carried out in 2022, where the argument was, could these amendments be surplusage? Supreme Court was clear enough to revisit and give. It's in the case of revenue at that point of time. I'm only saying that nothing is cast in stone.
You are worried about Pardiwala, sir, but how about N. Venkataraman, sir, becoming a judge?
No, sir. Let us assume, let us put it this way. Let us assume when he becomes a judge, to be fair to him,
Yeah.
maybe you should be in a position to tell him that this is what it is. Therefore, it's quite possible.
Today is a government council. He has to argue in favor of the government
No,
only.
you see,
No, everybody has done their job, sir. We are not pointing out anything against any
accepting the
person.
point.
But on the whole, if you see the judgment, it is judgment on morality, but not on,
That's what I'm
not a good judgment on taxation.
See, the decision in Jungli, which is basis for this entire decision on merits, was a decision on morality
Yes.
because that was on an police act in Tamil Nadu.
With regard to
Where they-
prohibition and the power of the state to
Where
regulate it.
Entirely it was morality because that's what the law is. Now, the moment you want to import that theory into a tax law is where the problem comes. And they should not have gone into.
And sir, also, I honestly feel Supreme Court, with due regards, the matter was the clarificatory in nature. Considering the wide ramification on the industry and global investors putting their money, at least they should have held that it should be prospective rather than being retro. To be fair, because again, it is a Vodafone type of a thing where you're changing the goalpost after, and it sends wrong signals to the global investors. And
It's on merits. See,
I don't know if this is as much as changing the goalpost like in the case of Vodafone. This is an interpretation of the law.
No, you take the example
That's
of
not a Vodafone.
It's not like Vodafone.
I'm
Basically,
saying
retrospective
it's perceived as-
a legislative amendment.
Yes,
it will be perceived as by the global
This is
investors.
very different from Vodafone. Yeah?
It's
very different.
If you see consistently.
In the perception.
Decisions that they have given, either in Jingli or in the Gameskraft or in the Tiger Global, what they want to repeatedly say that government has got the power for doing anything. So you have to.
No,
Like DPN sir said, Vodafone was the doing of the government.
No, I'm
This
not
is
talking
the doing
about
of the government. This is
I'm talking about.
When you have such high stakes, Badri, then why, and I've written that in the article on tax.
See the decisions, Tiger
You
Global,
put
Jingli
inputs
and
before the Supreme
Gameskraft.
Court. McDowell is also.
McDowell's.
input.
Yes.
You will get an
It is more
adverse
relatable to
when you put
McDowell's.
inputs before the Supreme Court because morality automatically grounds. It's an institution out of equity and justice. Equity takes into account the society also. Justice alone will win.
No,
the example you take the example of Tiger Global, which you said. That also was upsetting a jurisprudence for the past 20 years.
Yes.
It's completely upsetting a new.
But what
So
we have got the power to relook at it, whatever the understanding there.
Who is the we in your case?
They
Supreme Court or government?
yeah, we should now.
And they are empowering the government.
We should
By
get-
their decision, they are
we should
empowering
get-
the government.
We should get a normal actionable claim of a bank or something to test the law and reset it in a different way.
It will not apply. This judgment will not apply. I have said specified actionable claim. I have given a cargo
Yes.
and I did not make the mistake of betting and gambling in general sense. I made casinos, I made betting, I made gambling, I did online money gaming, I did horse racing. I have classified them into specimens separately.
Yes.
Betting and
That's true.
gambling is what I think in this case was argued as a sui generis, but Supreme Court said that they are interchangeable. Betting on gambling, what was decided in AIGF and all, Supreme Court said is a constitutional aberration. I think we need to respect that. That
Yes, yes.
clearly,
No.
a court cannot legislate upon.
One, secondly, as is pointing out, post 20, that's what I keep saying. Post 23, the government is clear what they are wanting to tax under online game.
Yes. Till that time, even government is also under confusion.
Exactly.
23
That is what
days there.
Come under it or you don't come under it. You don't come under it, don't come under it. Every actionable claim doesn't get.
You tax whatever based on the principle, but for the past period, it's very harsh.
That is where maybe the error of the courts is.
Sure. Done. So we'll close with this. And we can always, since we have all three of
Shivdas sir for bringing such a clarity because see, I have struggled to read Jungli Games and Gameskraft for almost about a week. I think he brought in from a tax perspective very precisely the point which we should worry about, to deliberate upon, discuss. There's a whole lot of things have been said and unsaid and all those things. That's a matter of detail. But I think for a person who is concerned with this judgment, I think all the relevant points are as brought up.
Absolutely, sir.
And,
Absolutely.
and I thank him also for the enhancements from time to time on every point.
True.
And
True, sir.
without that perspective in a way. Actually, we discussed the entire GST Act today, if I can say.
Practically,
Almost
yes.
the entire act has been discussed in about a couple of hours.
In fact, I think when Shivdas sir was saying that what is the relevance of that definition in actionable claim is the starting point of my definition section 2. I was instrumental in drafting it, and when I said this, actionable claims, we had taken it to the service tax. Finance Act also has defined actionable claims. One of the principles when we're following when drafting the law is what is already an approved text and a vetted text. Borrow it into that. You don't know the implications on this. Once it's a vetted text is existing in the law, we just borrowed it. But today, when you were saying that if it is not a wagering, if it is unenforceable, because one of the characteristics of the TP and the Transfer Property Act is that in order to be an actionable claim, it has to be enforceability.
Exactly.
Section 30 of the Contract Act bars enforceability in respect of the transaction of a wagering nature. So the reference to the actionable claim in 3 legs is stands. One is the right creation, assignment. Third is that enforceability. Enforceability 2 legs, 1 leg is gone. The remaining 2 legs, the actionable claim definition will continue to remain, but it has an impact on that.
That's what I'm saying.
Actually, Hari's service entire argument is based on that point only, whether it is enforceable or not.
No, if you look at, everybody has tried to.
Yeah,
I think
Yes,
there is
great
no
power
repetition by
state,
anybody, and
everybody
Supreme Court
has
has also
been-
captured it in such a way that I think each one, when they have argued multiple
yes.
arguments, but the essence of each one was captured without repetition. Submissions were never repeated. It was all very crystal clear, and each one of the senior advocate or the senior counsel we has brought in tremendous amount of insight into the whole issue thoroughly.
So clearly, the winners after the end of this discussion is the rest of us. Thanks to the 3 of you. Thank you so much. Thank you, sir.
Thank you. Thank you.
1 second.
Sorry.
I think I have been doing this duet with Shivdas sir from the date of the drafting days onwards.
We enjoy it.
The second time super hit.
We enjoy it very much.
Even while drafting, he used to question me and I used to give answers whatever with limited
I'll
knowledge.
tell you, all these sessions are immensely enjoyable and super learning.
Educative, very
That's
educative.
what I said.
Clearly, the winners are the rest of us.
Said that Shivdas sir is going to make the presentation. I said at least it's a good opportunity for me to learn, so I should be there.
Very important. Sir, may I take this opportunity to give you? Thank you, sir. Thank you, sir.
Photos. I need to do the repeat. Photograph. Okay.
Madhur, to Shivdas, sir. Please come.
Thank you.
Thank you very much.
Thank you. Thank you.
To previous.
Office better, na?
Yes, sir. That is why no clock.
Thank you.
Thank you, sir. Thank you very much.
On group photos.
On group photo. Everybody. Sit down. Stand up.
Please, stand.
All of you should come.
Those who are joined online.
Also group photo. I can.
Screenshot
Video.
Screenshot for them.
Photo edition can be done.
Where is Purushottam?
Thank you, sir. Manala High Court Judge.
Yeah.
Superb. SCG. Allah capture the button.
ಅವ್ರಿಗೆ ಕಾಣಿಸ್ಬೇಕಲ್ಲ